and good morning to all my fellow West Coasters. This is Ryan Thurman with Contact Center Compliance. I've got Joe Sanskrant with the Law Office of Joe Sanskrant here today to talk about some of the new FCC rules, what it means for everybody using dialers or not using dialers, calling consumers. Maybe we'll touch on calling businesses and get to some of the implementation guidelines. So Joe, welcome.
Welcome, Ryan. Thank you for having me.
We had a lot of questions on our last webinar on this subject a couple of weeks ago right after the FCC rules came out. So we thought we'd put this out to a little larger audience. We're expecting about 500-600 people today. Obviously, there's a lot of confusion thanks to the FCC and some of the press releases they put out before the rules came out. A lot of confusion about the types of dialer that are calls that are going to be allowed and when these rules actually are going to take effect. So those of you that don't know us, Joe works with the Law Office of Joe Sanskrant. He's kind of one of the founding fathers in the legal side of the fence as far as telemarketing laws go. He's also our in-house counsel when it comes to supporting our compliance guide solution. Very good person when it comes to trying to break down some of these laws. Our company, Contact Center Compliance, is more of a technology-hosted provider. We offer everything from do not call and wireless scrubbing to compliance regulatory guide, state registration tools. We also do a lot of phone appending for people that are trying to get right party contact. And we've got our information here for people that want to jot this down. We'll also be able to get this slide deck out to everybody at the end of the call a little later today with a link to the recording so that if other people in your organization want to check it out or if you want to take notes, go back on some of the sections, or if you have trouble sleeping tonight, this is probably a good thing to listen to. I'm just kidding. So I kind of mentioned some of the topics we're going to cover. Really going to look at the what's changed, what the differences are between the FTC and the FCC rules. We're going to talk about how that applies to pre-recorded calls. We're going to talk about the big change coming on dialer calls to cell phones and what you're going to obtain from your customers or the people you're working with if you want to continue down that route. And we're going to talk about the call abandonment change or the rule that was listed in the FCC. So those are some of the main things we're going to get into. We're going to take about 40-45 minutes of content. We'll have about maybe 10-15 minutes for some questions at the end. And you can just text those over via the GoToMeeting toolbar so that we can sort through those at the end. And if they're related to some of the content, we'll try to cover some of them during the slide presentation and the audio. So with that being said, I welcome everybody for joining. And Joe, we're going to get into some of the background here. So I'll let you take it away.
All right, great. Thank you very much, Ryan. I'm not sure if I like being referred to as a founding father. I don't know what that means, but it sounds good. I like that. I'm in good company. Now let's click on to the first slide here, which should be background, correct?
Yep, we got that up right now.
Okay, good. Hey, I'm not my viewer here is not advancing to the next slide.
You know what? Yeah, that was my fault. I neglected to turn on the screen, so you should see that on there now.
Aha! There we go. Okay, a few words about background here. This, the issue involving pre-recorded messages and how to handle pre-recorded messages, certainly in the telemarketing space, goes back to goes back for a long time to really the advent of the ability to send off pre-recorded messages using an automated telephone dialing system. But that led to a whole flurry of state and federal laws governing the delivery of pre-recorded messages, which in turn led the Federal Trade Commission to make changes to its pre-recorded rules back in 2008. And it was these rules that really represented a sea change for any entity that was making telemarketing messages using any sort of pre-recorded message. The first thing that the FCC said was, if you are sending off a pre-recorded telemarketing message, you have to get express prior written consent with a signature of the person to whom you are sending that pre-recorded call. On top of that, in any allowed pre-recorded call, you have to include an opt-out mechanism, and this could be via an automated key press or a voice-activated mechanism. The FCC had taken a look at the technologies that existed as of that time, and they felt comfortable in telling the industry that you need to include this option within any pre-recorded message that you send out. The key thing about the Federal Trade Commission, and this is a key thing in terms of comparison with the Federal Communication Commission rules, is that the FTC is what I call technology agnostic. They don't care how you make the call. They don't care if you're doing it from a predictive dialer or a manual dialer. Doesn't matter to the FTC, and also it doesn't matter to the FTC if you're delivering the call to a landline or to a wireless device. They just say if you're sending off a pre-recorded telemarketing message, you have to get prior express written consent, and you have to have an opt-out in there. At the same time that the FTC changed that element of the pre-recorded rule, it also had to address some issues because its pre-recorded rules also bump up against the abandoned call rule. And so the FTC made some changes to its the abandonment rate measurement rules. The FTC used to have a per day, per calling campaign rule in place, and to the I guess comfort of many in the industry, the FTC went to a 30-day per campaign standard, which kind of loosened things up a little bit, and it adopted a successive 30-day measurement standard, which means you start your campaign on day 1 and you measure the abandonment rate from day 1 to day 30, and then you measure it again from day 31 to day 60. Each successive 30 days, you take a look at your abandonment rate and make sure that it's below 3%. The FCC followed up in January of 2010 with a notice of proposed rulemaking. And in this notice of proposed rulemaking, the FCC correctly came to the conclusion that it had a set of pre-recorded rules that were different than the Federal Trade Commission. The FCC discussed the differences in terms of jurisdiction between the Federal Trade Commission, that the Federal Trade Commission has more limited jurisdiction than the Federal Communications Commission, and concluded that it was appropriate for the FCC to revise its pre-recorded rules. But here's the thing, the FCC in the proposed rules made it clear that it was going to stick with its existing rule framework. And this framework is not agnostic. That is, the FCC approaches this issue from the perspective of first, well, we have to look at how it is you're making the call. Are you making the call with an automated telephone dialing system? Or are you not making the call with an automated telephone dialing system? And then, is the call being delivered to a landline, or is it being delivered to a wireless device, or to an emergency number, or to a hospital? And the FCC is more or less stuck in that framework for the reason that Congress, when it passed its rules giving the FCC the ability, that the Telephone Consumer Protection Act, that gave the FCC the ability to create these rules in the first place, Congress had certain language in the Telephone Consumer Protection Act, and the FCC has to work within that framework. And it's, I guess it's regrettable from the perspective of the industry, because no matter what happens, unless and until Congress decides to either change the Federal Trade Commission rules or change the FCC rules, there's always going to be this inherent conflict between the FTC and the FCC over this issue of whether we're going to be specific with regard to technology or not specific with regard to technology. Last but not least, in the notice of proposed rulemaking, the FCC indicated that it wanted to keep its abandonment rate measurement rule, which was to measure abandonment based on a rolling measurement key. That is, rather than do what the FTC was doing, which was a successive every 30-day thing, the FCC's rule says that you just pick any 30 days within any campaign, and then you measure abandonment rate based upon that 30 days, and it's got to be within 3%. All right, is that really such a big bother to the industry? No, it's just a little bit frustrating to have two different measurements out there. And I wrote an article that discussed the notice of proposed rulemaking and kind of pointed out the fact that the FCC still had a different measurement rate for abandonment. All right, so that's the background. And moving on to the next slide, let's take a look at the specifics of what the FCC just came out with. Now, the first issue that everybody is interested in is predictive dial and pre-recorded calls to cell phones. This is the #1 issue for the industry. And as we all know, the FCC regulates automated telephone dialing systems, but going back quite a few years now, the FCC came to the conclusion that an automated telephone dialing system is the same, or that term applies to a predictive dialer. Now that judgment by the FCC has never been tested in court. Nobody has found the proper venue or the rationale to contest that conclusion. I personally believe that that conclusion is ripe for some arguments. The FCC really had to stretch the language of the Telephone Consumer Protection Act to take the definition of an automated telephone dialing system and make it apply to a predictive dialer. But nevertheless, that's exactly what the FCC decided to do. So let's call that water under the bridge for right now. The old rule, when it comes to predictive dial pre-recorded calls to a cell phone, was that you can't make such calls to cell phones without prior express consent. And I put in PDQ there just as a little joke. Not a good joke, but at least a little joke. So the old rule says you can't do so without prior express consent. Under the new rule, the FCC creates two categories. Category 1 is telemarketing, predictive dial, pre-recorded calls to cell phones, and category 2 is all other predictive dial, pre-recorded calls to cell phones. So the FCC created these two categories, two different worlds, if you will, for such calls, and then delving into the type of calls that I think are really important to the people on this call right now. The FCC divided category 1 into 3 different types of calls. So the first subcategory is calls that constitute telemarketing generally. Just the general category of predictive dial, pre-recorded calls that constitute telemarketing. Just like with the Federal Trade Commission, you have to get prior express written consent. And the same rules that apply in the FTC world, that is, you have to get a signature associated with it, that applies to the FCC as well. And the FCC adopted the FTC's approach with regard to e-signs. That is, if you can get an e-sign, electronic signature associated with the permission that you're getting, that will count as a signature sufficient to meet the rules that the FCC has promulgated. So I guess the good news for the industry is that, okay, now the FCC has in fact aligned its rules with the FTC. The bad news is that for those entities that were not regulated by the Federal Trade Commission and were able to continue sending off such calls to cell phones because they simply didn't fall under the FTC's jurisdiction, they no longer have the ability to keep doing that. The second category within these telemarketing calls to cell phones is such calls made by tax-exempt nonprofit organizations. And the old rule applies here. That is, you still have to get prior express consent if you're a nonprofit organization and you're doing some sort of selling associated with the call. You still have to get prior express consent. And the last category is just a special category related to calls that are made under the HIPAA rules. And I'm not going to go into detail on this. If anybody has any questions or is doing dialing related to HIPAA, feel free to contact me and my email address is jws@sansbrand.com, and that email address is given to you at the end of this PowerPoint. Okay.
Hey,
and then
I just want to intervene in terms of like why this is such an issue in terms of the calling to cell phones. It really boils down to the demographics of the people in the United States. That you've got anywhere from 30 to maybe 35% of the U.S. that does not even have a landline. They have ditched their landline in favor of just using their cell phone. And so it makes it much more difficult to reach out to these people if you want to use any sort of dialer device, predictive, preview, anything that the FCC would classify, right, as a dialer.
Well, you know, Ryan, you raised an interesting issue there. What exactly would the FCC classify as a dialer? And the key issue is, does a preview dialer meet what the FCC has determined to be the definition of an automated telephone dialing system? Clearly, the FCC went out of its way to say that an automated telephone dialing system is, in fact, a predictive dialer. But reasonable minds can and do disagree as to whether or not a preview dialer, that is some sort of mechanism where there is an element of human intervention before a single phone call goes out, whether that meets the definition of an automated telephone dialing system. I wrote an article for Contact Center Compliance in their newsletter where I make the case that a preview dialer is not an automated telephone dialing system, that we can put that into the bucket of a manual dialer. And again, reasonable minds can disagree, but that's the conclusion that I have made. And I think, you know, from my perspective, I tell my clients to treat a preview dialer as a manual dialer unless and until we hear differently from the FCC. But Ryan, if you have a different opinion, feel free to weigh in.
Well, it's not really my opinion. I'm not going to claim the credit for it, but I've sat in on a couple other sessions on this same topic, and their legal opinions were that preview dialer does constitute the definition of a dialer under the FCC rules. So it really is kind of, goes back to one of the things Joe and I have talked before, is how risk averse is your company? Are you willing to maybe accept the fact you might get a couple of complaints and have to defend yourself? There's no legal history on, you know, companies having been enforced on this issue, but it seems to me that you've got a pretty big fine to negotiate. Anything times 16,000, which is the current FCC or FTC fine, is a large number to try to work against. And the other issue is, and this is really more of a question, Joe, is because of the new definition with the FCC on a dialer, extra consent that you have to get on these numbers, does this open up the door for more TCPA kind of class action, private right of action cases where companies might see more of those headed in their direction because this kind of broadens the scope with the FCC's rules?
Yeah, I think so. I think it really, with the increase in the usage of cell phones and the fact that we now have this additional hoop that companies need to jump through in order to make a predictive dialer call to a cell phone, and also adding in the fact that, you know, it can be difficult. People will submit numbers to you, and maybe you make the conclusion that it's a landline and it's not a cell phone. There's great potential for mistakes to be made in this arena, and there are plenty of people out there, I guess plaintiff side attorneys, who are willing to take advantage of that. So, yeah, I think it would be fair to say that with these new rules, we can expect to see a flurry of enforcement, not necessarily from the FCC, but perhaps from the private sector.
Thanks, Joe. That kind of answered my question, and a couple other people had the same kind of concern.
Right. So anyway, to summarize the issue about preview dialing, there's my opinion, and then there's the wrong opinion about whether or not it constitutes manual dialing, and that was a joke. But again, it really comes down to the level of risk aversion that you have within your company. But bottom line, when it comes to this issue, if you are a telemarketer who's relying on inquiries, and whether these are oral or maybe via website, something like that, to make telemarketing calls with a predictive dialer, be on the lookout, because to make such follow-up calls moving forward, you're going to have to get express written consent if you're calling a cell phone. And that can mean maybe a checkbox on your website with language to the effect of, by checking this box, I'm signing this form and giving permission to ABC Company to contact me at the number provided. That would meet the terms of the e-sign rule. That is, the person who's checking the box has the intent to sign the box, to sign the form, recognizes that he or she is signing the form, and the language gives proper permission to indicate that the person understands, in fact, that they are giving consent to be contacted at that number.
Is that the same? That is the key right there. And is that the same kind of permission a debt collector or collection entity would need to have, or is that different with the new rules?
Yeah, debt collection is, let's just put that to the side for right now, and we'll talk about that in just a little bit.
Cool. You ready to go on to the next slide?
Well, no, I just want Category 2.
Oh, I didn't even do that.
Predictive dialer, pre-recorded calls to cell phones. I call this a catch-all. These are all of these calls other than the calls that we've identified above in Category 1. The FCC states that prior express written consent is not required for purely informational and/or non-telemarketing calls, and includes in this category such calls as research or survey messages, nonprofit fundraising messages, and informational calls by school boards, political candidates, airline notification services, bank account fraud services, and, you guessed it, debt collectors. So calls by debt collectors fall within this Category 2 catch-all provision. And just an additional note with regard to debt collectors, the FCC has ruled that predictive dialer pre-recorded calls to wireless numbers that are provided by the called party to a creditor in connection with an existing debt are permissible as calls made with the prior express consent of the called party. So that existing carve-out for debt collection calls that debt collectors have been relying upon, you have a situation where a person submitted their cell phone number in the context of the transaction that resulted in the debt that is being collected upon. You can still rely upon that because the FCC does consider that to be prior express consent. It's implied prior express consent, but that's sufficient for the FCC in the context of debt collection. Okay? I asked okay to see if the 500 people on the line will say okay all at once in unison. I don't think that's a good thing to ask, but so that's it for that slide. Ryan, let's go to the next slide.
I see everybody nodding their heads, so they must be ready to move on. And there are like a few questions related to this stuff, but we'll save those till we get to the end so we can get through some of the content. So we've got a little bit more here to chunk through.
All right, moving on to the next slide. Okay, issue 2, pre-recorded calls to residential lines. The old rule is that you needed to have prior express consent to deliver a pre-recorded telemarketing call to a residential line unless you have an established business relationship, and then no prior express consent is required. And this impacts the same thing on the FTC side. The FTC removed the EBR exemption back in August of 2008, and for these purposes, pre-recorded telemarketing calls to a residential line required express written consent. So the FTC moved very aggressively to require express written consent for all pre-recorded calls, and now the FCC has come out and it follows the Federal Trade Commission rule. First of all, you cannot rely anymore on an established business relationship when you are delivering a pre-recorded telemarketing call to a residential line. You have to get express written consent with a signature for any such call. And the FCC, just like before, it goes out of its way to make clear that this only applies to telemarketing calls and not informational and non-telemarketing calls. And I say the FCC goes out of its way, and by that I mean in the report and order announcing this rule change, the FCC spends a number of paragraphs really making clear that the new rule is not all the informational and non-telemarketing calls that I listed before, that this rule is not going to apply there. So, I guess a good scenario to explain this is you've gone to an airline, you've gotten your ticket, and the airline is nice enough to send off a pre-recorded call to your residential line to say, hey, by the way, your flight's been delayed by 5 hours. You might want to delay coming to the airport. And that's a good service. It's not offering anything for sale, and the FCC is just making it clear that you don't have to worry about that. Those calls can continue. And again, the new rule with regard to pre-recorded calls to residential lines does not apply to HIPAA calls. All right, so that's where things stand with regard to residential lines. And moving on to the next slide, we do have some changes that the FCC announced with regard to abandoned calls and how to measure abandoned calls. Brian, you want to go to the next slide?
Yeah, it should be up there for, oh, sorry, the slide deck went on pause for a second.
All right, beautiful. Okay, the old rule that the FCC had in place was to measure abandonment rate every 30 days across all calling campaigns. And the industry likes that rule. You can take all of your calling campaigns, put them all together over a period of 30 days, and if collectively the abandonment rate is at 3% or lower, then you're good. The FTC, however, requires measurement on a 30-day successive day basis per campaign. Okay, so the new rule from the FCC is basically the same as the Federal Trade Commission rule. You measure across a per campaign basis. It's successive 30-day periods, and the only difference is that the FCC still has that language in there that says that you have to disclose in the abandoned call message that the call was for, quote, telemarketing purposes, along with the name and telephone number of the seller. And the only reason I bring it up, this issue has been raised before, and I guess it's regrettable that lawyers interpret the rules that are coming out, because I think the average person going in reading this would just say, yeah, if you just say that the call, we're going to offer you something for sale, that indicates that it's for telemarketing purposes. But for whatever reason, in the rule, the FCC puts telemarketing purposes in quotation marks, which may imply that you're supposed to say that this call is for telemarketing purposes. I don't know how it breaks down across the industry, how many entities actually use the specific words telemarketing purposes and how many don't. But that's, again, an issue that is up to the discretion of each individual telemarketer out there, with advice of counsel, of course. Okay, so moving on to the next slide.
Automated opt-outs. We've got a few questions about this stuff floating around there, so hopefully we'll cover them on
all right, good.
Section here.
All right, so the FCC rule, and there are some differences in the automated opt-out environment, but if you're looking at the FTC rule, if you have a pre-recorded telemarketing call that could be answered by a person, you have to have the interactive voice or key press opt-out. If you have a pre-recorded telemarketing call that, quote, could be answered by an answering machine, you have to have a toll-free number disclosure. And, this kind of makes sense. If the pre-recorded call is answered by a person and you have a live person on the phone, you want to give them the ability to press a button or say, I opt out or whatever the interactive voice mechanism would be. And if the pre-recorded call is picked up by an answering machine, Well, if you want to give the person listening to the answering machine message the ability to make a do not call request, well, you're going to have to give a toll-free number so that the person can call and register a do not call request. The problem is the use of the language could be answered by a person and could be answered by an answering machine. There's no real way to know in the instant before the phone call, the pre-recorded message is picked up, whether it's going to be answered by a person or it's going to be answered by an answering machine. And the best approach, it appears to me, to handle this, if you're covered by the FCC rule, is to have the ability to provide an interactive voice or key press opt-out, and also make a toll-free number disclosure in the context of every pre-recorded telemarketing call that you make. And the FCC rule is it's better. Well, first of all, unlike the Federal Trade Commission, the FCC requires an opt-out during the abandoned call message as well. So the FTC rule applies to pre-recorded telemarketing calls that you're sending out to people. It does not apply to the abandoned call message that you're sending out. So the FCC, I'm not sure if this was intentional or how this came about, but based upon the language that the FCC has adopted, when you send off your abandoned call message, you should also give the person the ability to register a do not call and opt-out request to your company. With regard to the could be answered language, the FCC rule says that the toll-free number disclosure must be made during a pre-recorded telemarketing message that is, in fact, left on an answering machine. So if you have answering machine detection technology going on, for those instances where you detect an answering machine, you only have to do the toll-free number disclosure. Okay? So that's the story about automated opt-outs. And let me see if I have anything else to add with that. All right, let's move on to implementation. I think a lot of people out there were under the impression that this rule was passed and we have to implement it right away, and that is certainly not the case here. First of all, for all of the implementation periods that we're talking about here, all the time frames commence upon publication of the Office of Management and Budget's approval of the new FCC rules in the Federal Register. I haven't gone in to do research on why it is that the Office of Management and Budget has to approve the new FCC rules. It apparently has something to do with the Paperwork Reduction Act. But what I'm going to do is I'm just going to continue to vigilantly be on the lookout for when the OMB, in fact, publishes its approval of these FCC rules in the Federal Register. So we still have not had publication of the approval, and all of these implementation start points only begin when that occurs. All right, so for the abandoned call rule, the FCC has established a 30-day period. So for those entities that were not regulated by the FTC and now have to implement a new abandoned call rule, you have 30 days from the publication of the OMB's approval to do so. There's a 90-day period to put in the opt-out mechanism for pre-recorded telemarketing calls and abandoned call messages. And then we have a 12-month period for phasing out the established business relationship exemption for pre-recorded telemarketing calls to residential lines, and similarly, a 12-month period for implementing the rule that prior express consent has to be in writing for predictive dialer calls to cell phones. And again, for the majority of people in the industry, that's the big one, predictive dialer calls to cell phones, getting that consent in writing. I know that Ryan deals with this issue all the time with his clients that come to him seeking the ability to scrub out cell phone numbers because they're making use of a predictive dialer to call people. And Ryan, if you have anything to add with regard to that, that'd be great.
Yeah, I think the confusion that people have about scrubbing cell phones versus DNC numbers can be really clarified by a couple things. First, cell phone numbers today can be put on the national do not call list. That's a big chunk of the 204, 205 million numbers are on the federal DNC list. However, what this rule extends to is all cell phone numbers. So how do you figure out what all the cell phone numbers are, what all the cell phone numbers on your campaign list, your calling list, your customers, your inquiries? Well, there's a couple different databases you have to search on. We bring both of those databases in to perform what I call a wireless scrub. So we can essentially take a file in, scrub it, and turn it around and tell you which numbers are on landlines, which ones are cell phones. The reason it's complicated because two of those databases require kind of overlaying and interspersing between each other. One identifies the numbers that are basically owned by the carriers themselves, owned by AT&T, T-Mobile, Sprint, and a couple of other carriers. Those databases identify the numbers based on the area code and the exchange, and they have mini blocks. So you really have to know what you're doing with cell phone identification or scrubbing, or ideally have a vendor to do that. On top of that, you have the portability issue. So you can take your existing landline phone number, import it, make it your permanent cell phone number. And about 3.5 million people have done that. And so you kind of have to combine the two databases, bring them in almost a daily to monthly basis to be able to track these kind of changes. So one of the things we could do here is if anybody on the webinar isn't sure about how many cell phones they have on their database or doesn't think they even have them, because a lot of people will tell us that hey, we only try to get people at home. Well, if anybody wanted to take us up on maybe just getting a report on that, I'd happy to do that offline, run the file for you, give you a count back, and give you an idea. What do you have that's landline versus cell phone, so you know what you have to work against. We've already been doing this for a couple existing clients where their concern is how many people are we going to have to reach out to that we have as customers to get this extra consent? How are we going to plan for that? Because you've got a year or maybe however much time with OMB to get this implemented. So these are some things to think about.
Great. All right, so that finishes our presentation with regard to the changes implemented by the FCC. We broke it out into the pertinent categories and covered what we believe is most important to the industry. And Ryan, I'm sure we have at least a few questions coming in. And hey, that only took 40 minutes, so we have a little bit of time here, maybe another 10 minutes or so to answer questions.
Cool. Thank you, Joe. And we have another promo running right now, too, and you can just get with us offline. It's basically to take a look at something that a lot of people have struggled with, which is state registrations. As a telemarketer, a lot of states, if you're outbound, inbound, you've got to register just to call in a couple of these places. We've got a tool to walk through that, give you an idea of what your exposure is, make sure that what you're doing now is right. So if you want to get with us or go out to our website and sign up for a demo, you're able to do that. So let's get into some of these questions because there's quite a few of them. Again, this will cover about 10 or 15 of them, which is we are going to email out the presentation, the slide deck, and the recording, which usually comes out pretty clean, so you can stream that over your computer.
We're going to put it on YouTube.
Yeah, we could put it on YouTube. I don't know if I trust Google's privacy policies that changed today, but certainly an option. If you're aware of that, I'm sure you're chuckling to yourself because there's been a lot of stuff about that. Let's take a look at a couple of these questions. If you could maybe define call abandonment, Joe. A couple of people aren't really familiar with that. They're maybe not dialer people. Can you give a quick explanation of what call abandonment is?
Right. Basically, all the calls that you send out that are in fact completed to a live person. You take a look at that universe of calls, and for for everyone where you have a connection between the live person being called and a live telemarketer, that is a live call and that is not an abandoned call. However, for every call where there is no live telemarketer available to talk to that live person, that is an abandoned call. That is a dead air call. For if you make 100 such phone calls, 100 such connections to a live consumer, 97 of them need to be set up so that you're connecting with a live telemarketer. You're allowed, however, to have 3 of them that go to the abandoned call message.
And what you see in a lot of the enforcement is, like, if a company has a complaint against, let's say, for some do not call violations, maybe calling somebody on the internal list, they'll lump in on a lot of the enforcement extra penalties or enforcement against abandoned calls. I've seen that in some of the FCC stuff before.
Yeah, and it's it's very helpful that the FCC and the FTC have come to the same conclusion with regard to how to measure. I think a lot of people in the industry wanted to have the ability to combine across different campaigns because that offers some good leeway to do some interesting things. But from this point forward, it doesn't matter FTC or FCC. Just make sure that on a per campaign basis, and it doesn't matter how long the campaign is, or and it does get difficult. Let's say you have a small campaign. You're making 500 phone calls. It's very difficult to get to the numbers that are required to really get to a useful abandoned call percentage measurement. But here's the way I think about it. A campaign. What specifically is a campaign? The FTC and the FCC are not going to be coming in and telling everybody what a campaign is and how it is that you define what a campaign is. So there is a little bit of leeway, at least in that regard, because every telemarketing entity out there has the ability to define what a campaign is, and perhaps to avoid the trap of having a campaign with a lower number of phone calls, you may want to think broadly or more broadly about how you define a campaign, and you can take some of those campaigns and put them together and say, hey, this is really all one campaign.
That's some good advice on that end.
Well,
here's another question, and I've gotten this one a lot in the last couple of weeks. A lot of these people out there in the world of lead generation. The question is whether lead generation would be considered informational or telemarketing calls, specifically calling individuals to connect them to a third party, and that third party will be attempting to sell something.
Well, I mentioned that the FCC went out of its way to say that informational calls or non-telemarketing calls kind of fall outside of the new requirements here. But in prior pronouncements from the FCC and the FTC, for that matter, it's clear that when they're thinking about a telemarketing campaign, what constitutes a telemarketing call, they will look beyond the immediate effect of that initial phone call. That is, if there's a difference between a true survey call, which is a number of phone calls that are made to a statistically significant number of people to get a sense of some question of import of the day. That's a true survey call, and you're collecting information, and you can generate statistics. It is not a survey call to call up a group of people and say, for example, do you have a crack in your windshield? And then you collect all that information, and you use that information in a follow-up campaign from a windshield repair service. That first phone call would be considered to be part of a telemarketing campaign. And now I fully recognize that this is probably not what the questioner wants to hear, but I kind of pride myself on thinking as expansively as I possibly can with regard to the rules at both the state and federal levels. But the quick and easy answer is that if that's the the scenario that you're dealing with. That is, you're making that initial phone call because the people that answer the question in a certain way are going to be going to a third-party sales floor, then yes, that initial phone call would be considered telemarketing.
This is definitely a case of please don't shoot the messenger, because I agree with Joe that if there's an intention to sell something at any point down the line from that initial call, and you're not just purely doing it for informational purposes, the FCC is they've heard that one before, basically.
Yep, yeah, that's a good way to put it. I, of course, spend much more time and effort and words explaining that, but you summed it up very well.
I'm just reading some of these. There's some long ones in here. We'll probably go back to people on offline.
And by the way, very often Ryan will send me questions based upon, what's coming in off the webinar. I sometimes have the time to get to them. I sometimes don't. But if you want to go for it, if you want to just contact me directly at jws@sanscrant.com, I might regret doing this, but let's just do it. Go ahead, contact me, and I will do my best to reply to the questions.
As far as the express consent requirements, can you just accept somebody's initials on a web form? Do you need a full signature? This is really kind of falls under more of what constitutes a signature under the e-Sign Act, right?
Yeah, exactly. And 5-10 years ago, when you talk about a signature, everybody had in mind somebody signing something with a pen. I think everybody recognizes that, all right, well, the concept of the signature had to change because of the internet. And that's what the e-Sign Act is all about. The e-Sign Act gives authority for entities to recognize signatures that are not the traditional signature, a wet signature on a piece of paper. So any mark, even a check in a box or initials or whatever you want to put there, any mark that is put onto something, a form, a website, whatever, with the intent to sign that form is considered a signature. So there's a great amount of leeway out there, and people can be very creative in getting e-signs from people. And one area that I think is maybe not enough people are doing it, one area that needs consideration is how to get a signature in the context of a recorded telephone conversation. Given the language of the e-Sign Act, I think it can be done, and that's something that if anybody wants to discuss that with me, I'd be more than happy to talk about that.
Yeah, I mean that kind of falls under some of these other questions with, if you just get provided the wireless phone number verbally, how can you get consent over the phone? And there's obviously, you've got two sides of the fence. You've got debt collection type calls where somebody may be giving you the cell phone number versus, a telemarketing type exchange. You really have to have a way to authenticate that number and follow the e-sign rules, right?
Right. And I think a lot of people just don't consider that to be a possibility. And I'm not saying it's the easiest thing in the world, but I'm saying it can be done. That is, if you have a recording of a person that says, sufficient language to indicate that they understand that by this recording they are submitting a signature and that they understand, the purpose for why they're submitting the signature, i.e., to accept follow-up phone calls, then guess what? You have the ability to say that you have a signature of that person.
This is an interesting question. It's related to if a person or a company manually dials a person, can then they play a recording without prior consent? I think what they're saying is, can you manually call somebody and then hit play to play them some message? I mean, to me, that's still a pre-recorded sales call. I don't really know if that gets you around any laws. I don't really know what the intention is, but to me that seems like a little bit of a gray area.
Yeah, under the FTC rule, it doesn't matter. You're sending off a pre-recorded call. So you have to get written consent for that phone call anyway. So then the next question becomes, all right, you're not covered by the Federal Trade Commission. You're a banking institution or a common carrier or something like that, and you want to take advantage of the manual versus predictive dialer thing. And yeah, I think that's kind of a hole in the FCC rule. That is, there's nothing that will cover a manually dialed call. You manually dial the call, and then you figure out a way to put in a pre-recorded call there. And the only thing would be the difference between a manual and predictive dialer call only applies to calls to cell phones. So if you were calling a residential line, it doesn't matter whether you're calling manually or whatever. You're still sending a pre-recorded call to a residential line, so you have to get prior express written consent for that. But then we have this subcategory of a manually dialed call to a cell phone, and yeah, there's no doubt about it. That's a hole in the FCC rule.
What about companies outside of the U.S., Canada, offshore, calling into the U.S.? They, in turn, also have to follow these rules. There's no exemption just because they're not in the U.S., right?
Yeah, there is no exemption from a legal standpoint. So if you're calling into the U.S. and you want to comply with U.S. laws, you have to comply with these rules. And I guess there's a false sense of security out there. If you're an international company, there's a sense of, well, how can the FTC or the FCC come after me? But the fact is, there have been international enforcement efforts, especially involving Canada, by the Federal Trade Commission, so that the possibility does exist that an enforcement action could be taken against you in your home country. And then if you have any assets located in the United States, well, those are subject to seizure if any federal or state agency gets a judgment against you.
Yeah, and they have shown, the FCC, that they will enforce, especially Canada, offshore. I mean, they're actually a new group that was formed to enforce international calling rules and to cooperate among the government agencies. There was a press release a couple weeks ago about that.
Sure. But generally speaking, if you're an international company and you're looking for legal advice with regard to these laws, any attorney will tell you that, yeah, you're subject to these laws to the same extent that an entity is that has a physical presence within the United States.
This is a good example of a question where it kind of clarifies some of the confusion around the established business relationship exemption that people were using or are using to call wireless phone numbers. And the question is, do calls to cell phones for other telemarketing campaigns, not robocalling or pre-recorded, require express written consent, and does the EBR still stand for these type of telemarketing questions, these type of telemarketing calls?
Well, I think if I'm understanding the question correctly, it's similar to the other question that we had on manual dialing. Is that hole in the FCC rule still there? And the answer is yes, it is still there. And it's the difference between a predictive dialer call versus a manual dial call to a cell phone. And the fact is, the Congress of the United States, in the Telephone Consumer Protection Act, did not give the Federal Communications Commission the authority to regulate manually dialed calls to cell phones. Why they chose not? Well, just when the Telephone Consumer Protection Act was passed, the issue was that they wanted to address was automated telephone dialing systems, because there were huge, just millions by millions of phone calls that were being made to randomly generated or sequentially generated numbers, and so Congress wanted to address that. So they did address it, and that rule had an impact on cutting down on those types of phone calls. And the additional layer of question came up when the FCC determined that an automated telephone dialing system is in fact a predictive dialer. And so that cut into the ability of people to make predictive dial calls to cell phones. But that last category of manually dialed phone calls, guess what? It's still not regulated by the Federal Communications Commission.
But there are regulations at the state level where 5 states have come out with a rule that says, hey, in our state, you can't telemarket to any cell phones contained in the state. And we have a list of those if anybody's interested. So some of the states have realized there's a little gap there, and then they can put up a law and send out some enforcement letters. So definitely an additional concern at that level. So in the what can I do with non-consented cell phones, ones I don't have permission to call, they're in 45 states, you'd be okay as long as that cell phone number is also not on the DNC list. The other states, we treat them as kind of cell phone DNC states.
Exactly. You know, it's when you combine the fact that there are 2 federal agencies that regulate telemarketing and the fact that there are 50 states that each have their own separate rules in place, you know, it is very clear that any entity out there doing telemarketing, and whether it's straight up telemarketing or even informational calls that might have some element of telemarketing to it, you do need to be very careful, and that's why Ryan and I are here to help out as best we can.
Yeah, we got time for a couple more questions. This is a good one because it's timely with, we were talking about Google earlier, and the question is whether would a Google Talk number be considered mobile, landline, or both? Google Talk is where, or Google Voice, you know, they give you a number and you can route it to other numbers, or you can use it for chatting purposes, etc. I'd have to see an example of the number to see if how we scrubbed it, how it would turn up. I would think that's going to show up as a landline number because Google owns a block of numbers that then they transfer out. And if your intention is to call that number and you think it's a landline, then that's what it shows in your scrub report, then it's a landline. But
yeah,
I haven't really thought of it. What are your thoughts on that, Joe?
I'm going to say, yeah, let's make this one the last question. It's actually a good one to make the last question because this question is, you know, what technology is constantly changing, and you know, at the time the TCPA was passed, the issue that was being addressed was automated telephone dialing systems, and little did Congress know that predictive dialers were coming down the pipe. And now we have all these changes that are being made, but we have some innovations in the telephony space, and Google Voice is one of those innovations. And that's something that I haven't even thought about that. I have my hands full just dealing with all of the traditional questions that are out there. But I like Ryan's analysis. That is, if the delivery of the message is being made, I mean, it's being made to a number, to a telephone number of some sort, correct? I'm asking, I guess I'm asking you, Ryan, but yeah, that's what's happening here. So, you know, the best way to analyze it right now is, you know, what is the telephone number, a residential line or a cell phone number, as it's listed in, you know, the various compilations that are kept out there. So, you know, that's as far as Ryan and I can take that for right now. But I absolutely envision, you know, what about, I don't know, just messages that are being sent from one computer to another. You know, people have the ability to communicate over voice lines from one computer to another, and I'm sure marketers are going to start taking advantage of that at some point and try to deliver marketing messages, pre-recorded or live, directly to people sitting at their laptops. I mean, why not? And so how do we regulate that under these rules? I don't know.
And it's the same kind of gray area, and this relates to a couple other questions we can both close up, is regarding, you know, businesses that put their cell phone number out there as their main point of contact. How do you deal with that? You know, I mean, we're going to probably have a separate discussion about B2B laws in another webinar that we'll put on and try to rehash some of these other questions in another couple weeks. And that's a whole other separate topic of conversation. What do you do with business numbers? Or what do you do if you're doing pre-recorded or dialer calls to businesses? Do you scrub out cell phones? Do you scrub out DNC? Do you just scrub out a couple states that you might hear from regarding some of these other issues? So there are solutions around that, but you really have to kind of look at what type of campaign you're running, where you got the data, where the data is published, and it's just like with cell phones, you get the other issue, which is how do you know where the number is when you call it? What if you call them at 6 in the morning before the federal calling time restrictions? How do you prevent that? Some of these questions aren't really answered in the regulations, and so you have to kind of look at best practices and try to put together, a plan around it, so at least that you can document that you had some practice, some process before you made the call.
Excellent. All right, so I think that'll wrap things up for today. So thank you, Ryan, for the opportunity for me to come and talk to all these good people.
Yeah, thanks everybody for your questions. Obviously, we maybe didn't cover everybody's question. We tried to. We'll try to follow up after the webinar again with the slides, the recording, on some of the other questions that maybe we can engage in. And then we'll let everybody know once we get our other one put together in another couple weeks. If anybody has any other topics that are kind of related that they'd like to maybe hear about, we can put those in the hopper and try to get those done. But you got our contact information up there. You can contact me or Joe, and we'll definitely try to wrap things up at this point. We're getting close to the hour, and I know it's getting close to lunchtime out here in the West Coast. So let's roll with that. Again, Joe, great webinar today. Appreciate all your insight, because this stuff is enough to make even people in the industry that know it, have been doing it for 10, 15 years, make their head spin.
Yep.
So appreciate it.
So thank you, everybody.
Thank you.